We're ready on Opipari versus Hurd D622669. So sorry that we're already running pretty late this morning, pretty intense calendar. What appearances do we have, though, please?
Good morning, Your Honor. Shaka Chrome on behalf of Mario Opipari, bar number 8116.
Excellent. And let's have our additional, let's have Mom's appearance, please. Where is she?
We can't hear you.
Amanda Roberts, bar number 9294. On behalf of the defendant, Kymberlie Hurd, Your Honor, I'm appearing on behalf of Jason Stoffel, 88898.
Yeah, and although I'd rather not do this on the record, but I'm very, very concerned about this. So, how is Mr. Stoffel doing at this point?
Your Honor, he's been released from the hospital. He's at home. It's going to be a very long recovery process because he was hospitalized almost 3 weeks.
I know. That's great that he's home. I'm so relieved.
But he's home and he's able to communicate, and he's getting the treatment that he needs, so that's the good part.
Oh, it's fabulous. I'm profoundly relieved. And and we'll move on to this matter.
Your Honor.
Has Down syndrome, correct?
Ms. Chrome and I actually have come to some agreements, Your Honor, if we could put those on the record.
Let's get those first, since that'll really
Okay.
help streamline everything.
So we've agreed to joint legal custody with a specific definition. We've agreed to a behavioral order. We've agreed that exchanges will take place at the Henderson police station. We've agreed that the 4th of July will be with the plaintiff in odd-numbered years, defendant in even-numbered years. It will be defined as July 2nd at 5:30 p.m. until July 5th at 5:30 p.m. Defendant's grandmother passed away, Your Honor, so she has a funeral with her family members from July 6th through July 8th, so she will exercise that time with the child to take part in the funeral. We've agreed that Ms. Chrome and I will have a meet and confer next week regarding the child support issue. We've agreed to a senior judge settlement conference. I'm sorry, Your Honor.
I said excellent.
Okay, we've agreed to recording exchanges, and we've agreed to talking parents, Your Honor. There are 2 things I believe that we need the court to rule on today: the response time for talking parents and a custodial schedule between the parents. And I think we both have proposals. If the court could just hear from us on a limited basis on those issues.
I would mention that I think most of those agreements are excellent. I do have some concerns about recording the exchanges. That tends to lead to a lot of tumult. I hope you're indicating that all exchanges won't necessarily be recorded, but that if something untoward occurs, that the party would have the right to record the next one. Or do they really intend to record the exchange?
So right now, Your Honor, I think Ms. Chrome and I believe that they are still in the high conflict, and hopefully as this progresses, that the recordings will be limited.
Okay.
But they tend to be in a little bit of conflict right now, and I think with these specific orders that we've agreed to, it may help reduce the conflict. And maybe with the help of a senior judge, it can reduce the conflict even more. So I think right now the intent is that they will record, but as time goes on, they would not record. And hopefully with it happening at the police station, everybody will be on their best behavior, which is the goal. And Shaka can correct me, or Ms. Chrome can correct me if I'm wrong, but I think that's the intent right now. And I think with those 2 limited things, if we could just argue the response time on talking parents and the issue of what the temporary schedule will be, then really what we just need, Your Honor, from you is a return date after the senior judge settlement conference. And if we can't resolve everything then I guess we would have a trial on my client's request for relocation and the final custodial orders.
Excellent. Before we start with those couple issues, we're checking now, we may be experiencing some difficulty with a close-in senior judge, or even one through the judicial settlement conference. But the court has a informal arrangement with several other judges where outside of both programs we'll refer cases to accept.
That's acceptable to me if it's acceptable to Ms. Crum, Your Honor. Either way, I will
What
tell.
I wanted to clear up is of those several judges who I've come to an informal agreement sending cases back and forth, is Judge Ochoa. So I needed to check. I knew for a period, perhaps a relatively short period, there may have been a recusal from his department. I don't believe your firm is still on that, are they recused?
We are not, Your Honor. We just had recusals on specific cases with Judge Ochoa. So
Okay, very good. Okay, in the meantime, while we're checking on availability, go ahead and proceed with those two issues, Ms. Roberts, please.
Hang on, can I add just a couple more things? The first one is just paternity is going to be confirmed today.
yes, that's accurate.
It's not?
And,
Oh, it's accurate. It
It
is?
is accurate, Your Honor. He's on the birth certificate.
Perfect.
yeah. And then we've agreed that both parties will remove any posts from social media that
Oh, I didn't
disparage.
talk to her about that, and I didn't agree to that. We can talk about it in our meet and confer. I'm sorry, I didn't talk to her about that.
That's fine, then.
I'll put that on the list for the meet and
Fair enough,
confer.
but be aware that unless this case is an outlier, the standard order is, and from this court, is number one, have those must be removed immediately. And number two, if someone claims, hey, it wasn't me, it's some third party, the court most of the time concludes the person has control over the third party friend or relative who's posting adverse material about the other party. So this court goes pretty far in making people responsible for third parties. So just so you know that there isn't really a lot of suspense to how the court would rule if it's submitted to the court. But I would much, much prefer that the two of you include that among the other issues that you'll stipulate to, and that the court doesn't have to deal with it. Go ahead.
That's
Okay,
fine. I'll
and
put
then-
that on the list for the meet and confer next week regarding the child support issues.
Okay, very good.
Thank you. And then the only other thing that I would say is that at the return hearing, we want to reserve our rights to argue any issues that haven't been resolved. So
I agree with that.
Of course.
for us, it's not just a trial on mom's relocation. We're reserving the right to argue that there shouldn't be a trial.
Sure.
Right.
It is,
So-
but in addition, after the two of you meet, if it's not successful, did you want to have a mediation? Well, we don't need one if there's going to be a judicial conference. So, Ms. Roberts.
They've already gone to FMC, Your Honor.
Yeah.
So we just, the parenting plan that was drafted by FMC did not include all of their agreements.
Yeah.
And so it can't be entered. So I think that this is what we're doing in lieu of that parenting plan, Your Honor. And then, and Ms. Crum and I work together. Maybe we can come up with a plan that will resolve the entire case. And hopefully with either a senior judge or another judge, that'll resolve, Your Honor.
Yeah, because the
Yeah.
June 14th,
Okay.
I'm delighted to hear that some agreements were reached, because the June 14th correspondence I received, FMC said they didn't agree on anything. But, so I'm glad that you have some agreements. But about, let's start with the temporary timeshare till we return, till the settlement conference, or at least, go ahead, Mr.
So it's Ms. Crum's motion, Your Honor, so I'll let her go first and I'll just mute myself and she can argue those two issues.
Okay.
Okay, great, thank you. So regarding the custodial time, temporarily, we would agree to a joint physical custody, obviously reserving our rights to make any future arguments. And we are requesting from Thursday at 5:30 to Sunday at 5:30. But if a party's traveling, we want them to be flexible, so if the return is late, that there's not a contempt of court relating to returning late. They would just post it on Talking Parent and continue to exchange at the Henderson Police Department. And if I may, just regarding the exchange, what I would like to happen is that the parent who has the child remains in the driver's seat. The other parent opens the back door and just takes the child out of the back seat. And they don't communicate. They just post on Talking Parent until we can get to a mediation and resolve everything. I think it would calm everything down. And this child is mobile. It's not like, she can't function, but it would probably be nicer for a parent just to get her out of the car and take her into their car. So we're asking for Thursday through Sunday, 5:30 exchanges at Henderson.
Okay, excellent. Ms. Roberts?
So, Your Honor, we're not too far off, I don't think, on the timeshare. So what we had proposed is Dad would get Friday at 5:30 until Sunday at 6, which is still joint physical custody. And then we had proposed one overnight during the week where he would get 5:30 and return the next morning when he goes to work. This is the issue, Your Honor. And the court said it at the beginning of the hearing. This child has Down syndrome. She is nonverbal. She uses ALS, so she does communicate simple words, but she uses some sign language, and she requires constant care. Although she is 5 years old, Your Honor, she has the mental capacity right now of about a 2-year-old. She's still in diapers. She goes to multiple not physical therapy, but speech therapy, and multiple doctor's appointments a week. She's on medication for hypothyroidism and allergies as needed. These parents need to be communicating very, very frequently regarding this child and medication and what's going on. And so as it relates to talking parents, Your Honor, we're asking for a 6-hour response time. And I know that that is a very short period, and usually it's a 24-hour response time. But this is a special needs child, and we may need to keep up on potty training her and what's going on with speech therapy and what's going on with her medication and all of those kinds of things, and joint legal custody questions, Your Honor. Then it is absolutely necessary for us to have a short turnaround time. As it relates to the timeshare, Your Honor, what Dad is, Mom and Dad doesn't dispute this, Your Honor. When they found out that Mom was pregnant with a Down syndrome child, they agreed that Mom would quit her job and be a stay-at-home mom. So for the last 5+ years, Mom has been the primary physical custodian of this child. She has gone to every single medical appointment. She has gone to every single therapy this child needs. She has been the one providing the day-to-day care, Your Honor. So the issue is this. On Thursdays, Dad got the child overnight and kept the child until Friday morning. Fridays, our question is, who would care for the child? Because it has to be someone that has the ability to, number one, have a relationship with the child to understand her communication, who is physically capable of changing her diapers, making sure that our medications are given. So our proposal, Your Honor, was a first right of refusal. In the interim that does not work, Your Honor, then what we'd ask is that his overnight actually be on Tuesdays, and he would get Tuesday at 5:30 until the next morning at 9 o'clock exchange. And the real reason, Your Honor, is that what Dad is proposing is that his new girlfriend would be the caregiver of this child. And when Mom is available for a special needs child, it is our position, Your Honor, that the Supreme Court has ruled on those issues and said that Mom has preference over these third-party caregivers. And in a normal situation, Your Honor, when the child does not have special needs, I understand the court would typically not have a parent would not typically interfere with this, but this is a different situation because of the special needs that this child has. So those are the things that we're asking for, Your Honor. Talking parents' response within 6 hours, and that either if Dad wants Thursday until Sunday, my client is agreeable if she can have the time during the day when she is available with the child. The child does go to extended school, Your Honor. That starts in 2 weeks. So Dad can drop her off Friday morning at school at 9 a.m. She gets out of school at 11 a.m. So my client would get her from school and keep her from 11 until 5:30 when Dad is out of work, and they would do the exchange at the Henderson police station. Our proposal regarding the exchange, Your Honor, which might cut down on the talking parents communication, is that they simply have a journal that they exchange. The journal documents the things, what time did she last receive her medication, how is the potty training going, how is it going regarding the therapy that she's supposed to be doing on a daily basis? Have they completed it with her? What's going on? And with that, I'll end, Your Honor.
I appreciate that. Ms. Crome, you heard that when they were first indicating that they prefer the Friday evening to Sunday evening, but they'd agree to Thursday evening to Sunday evening, as long as there really will be cooperation and compliance with right of first refusal, whereby Dad has to understand if he's working and not available, his girlfriend may be a very appropriate caregiver. I don't know. She may have been read up on Down syndrome or whatever. Who knows? But even if all that were true, he would, by necessity, if we adopt this schedule, have to reach out to Mom and give Mom first dibs on getting Aslan back instead of Aslan being watched out for, but not whether it's Dad's girlfriend or some other third party. So. Otherwise, we have to look at some different schedule if a right of first refusal isn't going to work. And I'm not sure these parties are at the cooperation level you would need for that. But if they want to give it the old college try and agree to it, that's okay. So what do you think?
The problem that I have is that Mom for her wanting to journal, it just seems weird to me because she hasn't done that so far while she's been taking the child to therapy. To want this 6-hour turnaround is something that is new. All of her other withholding, which she's been withholding for months, all of her messages are related to who is he dating and what's going on in his life. So in this child, my client does not sign, and Mom will admit he has a great relationship with this child. He's been able to care for this child. It doesn't mean that, just because he's a working parent that he shouldn't have quality time with her. The grandmother has lived in the house. Both parties have utilized his mother as a third-party caregiver as well, which I've explained to counsel. The Thursday through Sunday schedule would work best for him because he's off on the weekends. If this court is inclined that he would have to give up a day, if he doesn't agree to temporarily a right of first refusal, then he'll do temporary right of first refusal. But I think based upon the extremely high conflict nature of this case, where Mom has blasted Dad, made allegations, and then she withdraws them. She says he's violent, then she withdraws that. She says he's committed acts of sexual violence against other people, then withdraws that. That I'm concerned that if we include a right of first refusal, she's going to honestly stalk him and make new allegations against him. It's just going to increase the issues in this court, and it'll be harder for us to resolve it. I think that he, as a parent, has a fundamental right to parent when this child is in his custody. He's been able to do so successfully until she withheld the child. Mom, again, we're hoping the schedule works because Mom has confirmed in her paperwork that she's on her proper medication, and we're hoping there won't be any new suicide attempts because she's had 2. So we're taking this cautiously, but to add more stress of them interacting and him having to contact her every single time that he's not available, my concern, she's going to come back before you and say, see, Judge, I have primary. Just because a parent works doesn't mean that they're, failed to be a caregiver for their child. And Mom's going to get a job.
Well,
so hopefully she'll get a job soon.
It would be understood this temporary arrangement, they'd be precluded from arguing that additional timeshare to bolster that on a very temporary basis to use to bolster a permanent custody request. In point of fact, the court, rather than bean counting, would probably give some real brownie points to Dad on that issue. Wouldn't that make sense? If I see that level of cooperation, because these things are hard to monitor or approve, whether someone's going to be gone always to work in a given day, all of this. So if someone goes out of their way to be totally candid and offer the other side, yes, I got called in for another shift, or I got so many errands today that I'll be gone 6 or 7 hours, so you can have Ashlyn. I think that would inure to his benefit to a significant extent. I think even though, I share your concern about too much interaction and that rights of first refusal are reserved for the most cooperative of cases, which this doesn't classify as, I agree with you 100% on that. Yet by the same token, this would be a golden opportunity, arguably, for him to bolster his ultimate custody case if it looks to the court like every time that he's very honorable, and every time that he's going to be gone 6 or 8 hours, he tells Mom and effectuate an exchange. So, because I'm kind of inclined on the right of first refusal to go the Thursday to Sunday, if he can commit to that cooperation and decency level and candor level, but more so that if we don't have a right of first refusal, it would be more week 1 the Thursday to Sunday, and week 2 the 3 days, and then week 2 the 2 days Friday to Sunday, and then we rotate until we return. So whichever option you and your client find more palatable, you could tell me that now.
Yeah. He has missed so much time, Judge, that he will agree to the right of first refusal temporarily, but I would ask that the court make it mutual so that when Mom secures employment, they can just post their schedules on Talking Parent. If I can address the 6-hour issue.
This isn't just him agreeing to an order so that he can secure more time. and if you need a breakout session with him, because he has to really commit to the process. I don't want him complying just because it's a court order, because candidly, in pure enforcement for court order purposes is going to be difficult to prove. He has to be on the honor system, and we have to change the way we do business, so to the point where we don't even have to question whether he's complying with a court order, because he's a font of cooperation. And as Ms. Roberts said, everyone keep a journal and everything. So if you feel that
he is, and so
if you feel your client is really going to play fair with mom and inform her, even if he thinks it's going to invite some unpleasant dialogue about historical material, he needs to commit to it. And it could be
he did. When I put you on mute, Judge, he said he's committed. What my concern was is that if she gets a job in the interim, I would ask that she commit as well. That was from me.
I don't necessarily think, with what we know of the dynamics here, including medical, psychological, historical, I don't necessarily think we have to worry about, it's long term, that's a necessity. It may even be a court order, arguably, but I don't think we have to worry about any full-time employment necessarily occurring in the next 2 or 3 months, but until we return. But Ms. Roberts could obviously speak to that more clearly.
Your Honor, if mom gets a job, Your Honor, I don't think that she's disagreeing that there would be a first right of refusal, because I think under joint legal custody, they both have a right to know who would be caring for the child. My client's position is that grandma has only been able to do it like a couple hours at a time, because she's not physically able to do it more than that. So Kymberlie, can you just unmute yourself and confirm that if you get a job, first right of refusal would be given to dad as well?
Yes, I confirm that.
Perfect, Your Honor. So that's the confirmation. And then the only thing we need from you, Your Honor, is the response time on Our Family Wizard.
Right, and if I could just respond to that, I just worry about there being additional issues of contempt. If they could both post on Family Wizard, I suggested that he post on Wednesdays, just kind of update of what's going on during the week or whatever, or whichever day of the week. So he could do it on Sundays, and that she would do it on Wednesdays. And then if there's an emergency, they send a text saying, I need an immediate response to Talking Parents, can you please look today? That they would text that. But to recommend every 6 hours when he works full time, we're going to be back here on, contempt issues. And I don't think there'll be that many emergencies. She takes the same medication.
You don't really think that this court would hold your client in contempt on that type of issue? Maybe if he refuses to return a child for a long period of time, maybe. But something like that, this court's not punitive or draconian like that,
Right, so why have it in an order? You know what I mean? If there's an emergency, they should start communicating regarding emergencies. I think they don't need to pass a journal. They should use the app as a journal instead of passing a book back and forth.
Your Honor, may I address that? Sorry, Shaka.
That's a good
No,
point.
go ahead.
That's a good point, though. Yes.
So, Your Honor, and I have no problem if Dad were actually responding on Our Family Wizard to Mom's questions that are joint legal custody in nature, then I would have no issue with not having response time. The typical response time to Our Family Wizard from almost every judge that I've ever been in front of is 24 hours. But this is a special needs child. So when Mom asks a question about their special needs child and doesn't get a response for more than a week, that's not acceptable to me. That, in fact, raises questions about Dad's fitness.
True, but can we commit that the 6 or 8 period, not necessarily emergency matters, but matters of some seriousness or medical or care of child import, that it would have to be something non-frivolous or not minor. If it's something of some real arguable significance, then everyone has their phone. Dad has his phone with him. He arguably gets breaks or lunches at work. So if it's something important, and no, I can't define important today, that's totally subjective, but something important, he can be expected to respond in 8 hours. If it looks like he's being bedeviled with minutia, then as you both indicate, that's something else altogether. One person's minutia may be another person's quote unquote serious issues of import, so who knows,
I think that's acceptable, Your Honor. What I will do with Ms. Chrome today, actually, is the questions that have gone unanswered, because my client says that there are 8 outstanding questions on talking parents that have been weeks old or days old. I will communicate those with Ms. Chrome, and if she can respond to me by Friday with the answers, then I think that will resolve the outstanding issue, and then going forward, we can just do the 8 hours response time on the issues regarding the child.
I don't think.
I'm fine with responding.
Based on how things are progressing, when you all 4 get around the table, and arguably with a neutral, if not all 4 of you by yourself, I don't think you're going to have any real trouble settling the case, except for one big issue. If mom still intends to relocate to Florida at this time, then obviously we probably have a trial issue, because I don't want to jinx any settlements, but I doubt we're going to see a stipulation by either parent that someone can move out of the state with their daughter, but I could be wrong about that. But I mean,
I still think we want the
I
senior.
guess there's an undercurrent to my remark. Can they reach a settlement where the Florida relocation is not necessarily denied, but it's deferred and could conceivably be
Absolutely, Your Honor.
a later
Yes,
date?
that's why we
Because-
suggested the senior judge
because
settlement
there's really,
conference.
it's not like there's a really compelling, unique job offer there or anything else, or any huge financial, maybe there is some financial benefit, but time is not of the essence on that necessarily. So that's why I'm suggesting maybe, since I don't think you'll come to I know you're not gonna come to a resolution if we expect someone to agree to the relocation, but you also may have trouble coming to a resolution if it's denied outright. So if you can agree that it's deferred, but the court has jurisdiction to deal with it over the next year or 2, if mom presents a pretty solid case, then that kind of qualifying language that gives everyone a little flexibility and a lot of wiggle room might kind of help. So please keep that in mind.
Yes, Your
Okay,
Honor,
and
she's
then-
willing to discuss removing the request to relocate if we can settle the case.
And I think if you remove or at least defer that request with the understanding it can crop up in the future if there's enough substance to it, I'm confident you're going to get the case settled. This is the way it sounds.
And I believe it can be settled, Your Honor, with the assistance of a senior judge or a sitting judge. So I can prepare the order and send it over to Ms. Crone. I will get her the letter today regarding the outstanding issues on talking parents. And then I think that we can work toward a settlement conference as based upon the terms that the court has given us today.
Sure, and
And
for
then
today's purposes, we accept a joint legal custody, specific definition, parties have stipulated, that'll be in the order. If they need a behavior order, one can be provided. The attorneys will meet and confer on child support, and the other, if they also want to deal, I think we've resolved the temporary issue pending a settlement conference as to custody, but they can settle ongoing custody, or at least custody till trial, or hopefully no trial will not be necessary, and they can arrive at an indefinite schedule. I hate to say permanent. Talking parents, 8-hour response time is reasonable with Aslan having Down syndrome, providing that it doesn't have to be an emergency, but it has to be a relatively serious issue of import, and I can't define that now, and there'll be subjective opinions on that, which vary between the parents. Plus, I like the idea of the weekly updates that was suggested, so that should be imposed. The recording the exchanges, I'm not thrilled about it, but I kind of hate getting in the way of stipulations by skilled counsel of this caliber, so so be it. The senior or judicial settlement conference is ordered, and we'll see in a minute what the specifics of that is. Of course, paternity is confirmed. I expect that I don't really wish to, unless the attorneys insist, I don't wish to postpone the social media removal posts as to adverse material, because it implies that some sort of stipulation would be reasonable that does not embrace a complete aggressive requirement to remove immediately and to control third parties and direct them to remove immediately. And in fact, I am going to not take that off the attorney's plate, so they have one less thing to worry about, because the only stipulation the court would accept on that is all such material should be removed within 24 hours. If at the conclusion of this hearing someone tells me they need a little more than 24 hours to remove it, they will. And then step two, they are to direct all third parties connected or associated with them who are giving them moral support, quote unquote moral support, by helping them bash the other side on social media. If that dynamic exists to any extent, you instruct those friends, those relatives, significant others, whatever, to remove that material. That you appreciate you appreciate their moral support and them lending a shoulder, but unfortunately this situation, although well-intended, is only going to really damage my custodial chances. That's what you're to tell them. Then if they won't remove it, I expect a sworn affidavit under penalty of perjury with specific dates, times. I told Aunt Myrtle to remove this post on such and such date. I even told her that it's going to harm, not me, but will harm my custody case if she doesn't remove it. And Aunt Myrtle said, pound sand, F you, no one can tell me what to do. And the other side deserves this, I'm just telling the truth or whatever. And that I implored Aunt Myrtle to remove it. That's the degree of specificity I would need before I tell a party, okay, you're right, this third party's out of control, and even though they're associated with you, neither you or anyone could control this person. So I really have a no-nonsense policy about that, because even though we have a Down syndrome child who obviously cannot read or comprehend the material, she'll be of an age in the future where someone, if this problem lingers and these matters linger and escalate, if she's 8, 10, or 12, or even younger, and people start telling them, oh, I saw this about your mom and dad, it's really a horrific situation. And the studies on these are just starting, and it's alarming the long-term effect. At this time, we don't need a technical, physical, custodial designation, but Dad will have Thursdays 5:30 to Sundays 5:30. The right of first refusal, the court's taking a leap of faith, because I'm impressed and delighted with the progress. The attorneys are gutting a lot of the case right here with stipulations. It only tends to work in the top 5% of cooperative parents. These parties are not remotely close to the top 5% at this time, and still remain in moderate to even high conflict, depending how you look at it. But under the circumstances, I believe Dad, when he instructed Ms. Crum to agree to this, it appears to the court that he understands and is committed to make this work, and he will be on the honor system. And even if his significant other were to tell him, hey, I can handle this. What's the problem? Don't you trust me? He says, of course I trust you and know you love and care for Esselyn, but this is what I'm required to do to get this additional time for now, and I just have to. I'm on the honor system now. We haven't exactly agreed. I don't think whether that's 6 or 8 hours or what hours would apply to that. So we'll see where we are. If mom has any special instructions as to Esselyn's Down syndrome situation that she thinks Dad is not as nearly as clear on as Mom, and it would appear that may possibly be the case for no fault of Dad, but just by the fact that Mom has been sort of the expert and the caregiver primarily all along, and the point person as to Down syndrome issues, although I'm not, of course, at all minimizing Dad's incredible love and contributions in this arena. But if there is anything like that she's a little uncomfortable because she's not sure Dad knows about either education, tutorial matters, diet, or intervals of medication and MG's amounts of medications, she'll put that all on Talking Parents and make sure that Dad has the list, or you exchange it at the settlement conference. Mom, of course, has to, and it doesn't sound like it's an issue, so it's probably an unnecessary order, but Mom, of course, has to remain on all her prescribed medication and follow all medical/therapeutic instructions. I haven't heard that she's not, but that's just a standard order the court issues if a parent experiences certain medical and or other challenges. So at this point, if there's any medications to address either depression or anxiety or anything else, and I have reason to believe there are, and they may be multiple, as like 3 or 4, as long as she remains on them and follows doctor's orders, it's a issue. And of course, I haven't heard anything medical applies to Dad, but if so, then of course it's a mutual order. Now, as far as the exchange at the Henderson Police Department, if we're not going inside the police station, but dealing with these issues of, well, this person can approach, this person will remain in this car, and this other person will be 8.7 feet away and at a 68.2 degree angle and all this, and the lunar eclipse has to be in this position. The problem with all of those sorts of behavioral minutia conditions, although certainly well intended, it might have the opposite effect. I think we have to streamline and simplify. Instead of these rules, who approaches the car, who remains in how many feet away, park the cars, walk into the Henderson Police Station, inside at the sergeant's gate. Either that, or you exchange at the family court gate here at the assigned times, or some other, or if you want to remove that sort of supervisory / law enforcement type of oversight, and they feel comfortable at a food court somewhere, or even dropping off at each other's homes. I wouldn't recommend that now, but we can loosen if you need to keep it with a law enforcement type element, it'll either be the family court gate or inside the Henderson Police Department. I don't want them exchanging each other's houses unless there's a stipulation to that, which I'm not hearing. If they feel comfortable at a food court or a hamburger stand or someplace that's very busy, and they stipulate, I'm not too concerned. I think we'll be all right, but I'll leave it to the parties. So before we get our information about the settlement judges, let's see. Now,
May I ask a couple of things,
as far as
Sharon,
that
when
last
you're done?
issue, where do they wish to exchange?
So, Your Honor, my client's position is that the Henderson Police Department is convenient, and
Yes.
so it works for both of them. Unfortunately, the Henderson Police Department is not open when they do their exchanges because of COVID-19, but it is in the parking lot and there's recordings. So what I would suggest is, given that we can record exchanges, my hope is that with the specific orders from this court, that we can start reducing the conflict for these parties, and that Ms. Chrome and I, if there is an issue in the future, could come up with a more defined method if there is an alleged problem with the exchanges. So my thought is, let's let them do this exchange for like 30 to 60 days, and if there's an issue, Ms. Chrome and I can communicate regarding that and hopefully resolve it. I mean, we resolved the vast majority of the issues today with just our communication this morning while we were waiting for the court, and I'm not complaining about that because it did allow us I just want to be clear, because it did allow us the time to go over all of those, and I feel that I have enough client control and Ms. Chrome have enough client control that if we can't resolve this, that we could resolve this issue in the event that a problem crops up in the next 4 weeks.
You know,
So
again,
as to
keep
the
in
specific
mind,
method, I think we should leave that undefined.
Yeah, and I think this case should settle because it does appear to the court that what's being discussed may not really be what's at issue. I don't think either side honestly believes their daughter is not receiving fine and full care, sufficient care with the other parent. I think that it's a very unfortunate situation where mom, who is not necessarily a younger parent and may even have, I believe, a young adult male child at this time when she had Ashlyn, and Ashlyn has Down syndrome. They needed this intact relationship to make this work, and it appears there's some real devastation. Not only did Dad leave the relationship, but hooked up with someone else almost immediately. And I'm not bringing that up to make the parties feel bad. In fact, quite the opposite. I think if we recognize what's going on here, that there's some real hurt, and that's what's going on, some real hurt, and mom has apparently a right to be hurt or even devastated, but still she has to recognize, and they both do, that issue is separate and apart. The court really can't do anything about that. I just have to make sure their daughter is adequately cared for by both, and it seems she's is receiving sterling care with mom, and I don't have any real doubt at this time that dad's also going to rise to the same level or comparably so. So the parties have to understand this, the baggage and psychological dynamics between the two of them, which I'm not minimizing, are devastating, I think, for mom. But we have to do our best not to let that bleed over into these issues of arranging a fair schedule with Ashland and recognizing the great benefits that both parents bring to the table. And I dare say substantial progress with the wonderful assistance of the attorneys is occurring in that direction. So let's move on with that approach that we've heard today and not get backtracked to the kind of tone we heard in the paperwork, which kind of had the court thinking more in terms of the devastation and hurt and tumult in the relationship and how mom suffered by that breakup, and understandably so, and dad maybe candidly jumping the gun a little bit, which is just going to add fuel to the fire, getting into a new relationship right away. So all I'm saying is I understand how the parties feel about those issues, but then I double read the briefs, and it still came across that way, that I don't really have to be concerned that this little girl is going to receive the full love and support of both parents, and we kind of have to compartmentalize those other issues, as difficult as they are, and not let them bleed over. But with that all said, again, if mom does have some legitimate concerns as to is dad really on top of all these issues to the extent he should be, that's why I instructed her to prepare a care sheet that Ms. Roberts will make certain can be transmitted at the settlement conference or earlier. Now, that all said, what did we find out about a settlement conference?
The law clerk is going to work with Ochoa's department.
Okay, and I think I better pose that to Ms. Roberts. It looks like with the senior judge formal program and the formal judicial settlement program, which should consist of currently sitting family court judges, of course, well, the senior program is the retired judges. It looks like we don't have close availability, and to these judges who assist with overflow, it looks like Judge Ochoa would be the most obvious candidate for a very close-in referral. And with the understanding, of course, that this is not arbitration, but it's just mediation, having a conversation with the judge to assist with settlement. Is there any objection? Do you want us to try and secure Judge?
No, Your Honor, not at all.
Okay.
No, not at all. Judge Ochoa, I have no objection with Judge Ochoa unless Ms. Crum does. I'm fine with Judge Ochoa doing it.
Right, and I'm just erring on the side of caution because I know that material the court referred to is way back in 2013 or 14, and but I just wanted to make sure, and you already answered and say there's a possibility of a case-by-case recusal, but there's no blanket recusal. So we'll coordinate that. Or should they contact his department directly or coordinate it through ours?
Probably contact.
Okay.
Your Honor, can I make one more request?
Yes?
Can I make one more request? So previously on one of the exchanges, they were operating where mom was taking the minor child while dad was at work. And so he would meet her before he went to work and then pick her up, that night. So it's anticipated she's going to take every Friday. So in exchange for doing that the last time, he had Tuesday to Wednesday at 10 a.m. So, and I think mom liked that schedule. I'm not sure, so I'm just asking if we could have a schedule where he would also have, Tuesday night to Wednesday morning in the exchange, and then because we know every Friday she's going to have the child until he gets off of work.
There's no prejudice to dad for mom exercising the time while he's at work. So at this point, the schedule is joint physical custody. We can see how this schedule works, and if it doesn't work, then we can come up with some other plan and try to look at that. I don't have a problem with that, but I think we're rehashing everything we've already gone through if we then ask to modify the schedule further.
Right.
He on a Thursday through Sunday, and she agreed.
That can be thrashed out at the Ochoa conference. Now, should we have a 90-day return as to status / results of settlement conference, a 120-day return, or are you hoping to get before Ochoa just within the next month or next few weeks, which I think he'll be able to accomplish?
My concern, Your Honor, is Judge Ochoa, we've asked for an OST, and he's indicated that he doesn't have any time. So I'm thinking it's at least 120 days, but if the court has an indication that it's going to be...
We'll make it 120, okay. But what you identified could possibly be a slightly different dynamic. A judge may not necessarily have a lot of court time for
Absolutely, Your Honor.
They still may be able to arrange a settlement conference on their so-called admin day, but I hear what you're saying. So we'll make it 20 just to be safe, but hope the conference, you'll try and arrange that immediately and try and meet with them within the next month. okay, on 120-day.
That's fine, Your Honor.
For status/results of settlement conference.
Can we say, just because I'm covering Mr. Stavel's cases, I can't guarantee I can do it within the next month, Your Honor. I have a lot of
No, you don't
trials,
necessarily
so I
have
could
to. It's
agree that
just-
we could try to do it within the next
Right, you
60
don't-
days.
You don't have to, it's just that we don't want it 90 or 100 or 110.
Oh, that's fine, Your Honor.
It's more of an aspirational remark by the court. If it has to be 2 months.
That's
or
fine.
whatever. Okay, so the date, October
21st at 11.
October 21st at 11, please. October 21st, 21 at 11. Status.
Yes, Your Honor.
Status/results of settlement, judicial settlement conference. All right. Great work.
I'll
everyone.
prepare the order and send it over to Ms. Chrome, Your Honor.
Great work. Thanks so much. Schedule starts
Thank you, Your Honor.
immediately. Thanks.
Yes, Your Honor.
All right, thank
Like
you.
today.